Good evening. If you're interested and care about the U.S. Constitution and freedom of speech and press protected by the First Amendment, or if you care about the role of journalism and the press in informing the public about important public issues, or if you care about the roles and rights of leakers of government classified information, or the level of information the public needs to exercise our responsibilities of self-government in a democracy, or the role of the state in keeping its citizens safe and in functioning effectively, or in the perplexing problems of working out a global system of free expression in a new world defined by a truly global communication system and nations with vastly different views about freedom of speech and press. If any or all of this interests you, then tonight is your night. We can look forward to hearing from distinguished leaders of some of the most important press institutions in the world, which have had direct, recent firsthand experience in these issues, and in Cass Sunstein, one of the key figures in the current surveillance debate, who also possesses one of the finest legal minds of my generation and who has been a friend and colleague for many years. The questions to be discussed tonight are profound. Among them is this one in particular. In the United States, we have worked out over the past half century through major Supreme Court decisions, led by the Pentagon Papers case in 1974, through legislation and through custom and behavior by the government and the press, a workable, if unique and somewhat unruly system. It goes something like this. There is no official secrets regime in this country, as there is, for example, in Britain. The government has full constitutional freedom to classify information as it wishes. For its part, the press may receive classified information from government employees who are disposed to hand over classified documents. Moreover, subject to a variety of legal subtleties and nuances, the press may publish those classified documents with constitutional protection. The leaker, on the other hand, may be prosecuted with little or no First Amendment protection, the only question being just how vigorously the government will track down and prosecute the leaker. In practice over the years, not many leakers have suffered that fate. Also, by custom, the press will typically discuss what has been in its possession with the government and make a careful judgment about what to publish and what would be too harmful to publish. And the government, in turn, does not try to push the legal interpretations that might support a breach of the First Amendment protections of the press. Every nation must reach some sort of balance and accommodation of these competing interests. And arguably, up to now, this has worked well in the United States. But what happens now should the balance be struck in the same way? In a world in which hundreds of thousands of classified documents can be leaked in a second by leakers who may wish to do harm, not good, to society, then disclosed by organizations that are not necessarily public-spirited in the sense of the New York Times, the Guardian, or the Washington Post, and when any publication is now instantly global in scope and may violate the laws of other nation states. What now, indeed? These are the kinds of questions, like others involving state acquisition of massive data about activities of citizens, that constitute the anvil on which a society ultimately defines itself, especially in the respective roles of the state and its citizens. So tonight's discussion is a special moment in that larger sense. It is now my great pleasure to introduce our wonderful new Dean of the Graduate School of Journalism, Steve Coll.
Thank you, Lee, and welcome. Tonight's event marks the public launch of a project of the Columbia Journalism School called Journalism After Snowden. It's a project made possible by the Tao Foundation. I'd like to recognize Len Tao, who's sitting with us tonight, for his support. And it constitutes a year-long series of events, research, and writing from the Tao Center for Digital Journalism, which my colleague at the Columbia Journalism School faculty, Emily Bell, directs. and it's being carried out in collaboration with the Columbia Journalism Review, whose new editor and publisher, Liz Spade, is here with us tonight. As Lee has so eloquently described, and I won't attempt to repeat, the Snowden affair has sparked an unprecedented debate about digital privacy, the pursuit of national security after September 11th, and the power of the state. It's also sparked an important and continuing debate about constitutional rights in the United States and globally governing the press and free expression. But it's also changed journalism and is in the process of changing journalism and has raised profound questions about the practice of journalism that feel very unsettled. And that's going to be one subject of the panel tonight. These include shield laws and subpoena defense, the sort of frontline experience of reporters under pressure in their relations with confidential sources, the very viability of a regime of source protection in the digital age, how to define and spread sound practices of digital security, and the growing professional-amateur divide in journalism caused by the deinstitutionalization of many reporting functions. All of these are subjects of the larger project of Journalism After Snowden. It will constitute, over the year ahead, a series of articles about the implications of state surveillance and for the practice of journalism, research about changing journalistic conduct in a time of data insecurity and state surveillance. And we intend to carry out an in-depth survey of the practices of investigative reporters, their use of digital security tools, their understanding of them, and the potential to improve the security practices of working journalists. And finally, we intend to bring forward online resources that will be available to all journalists to assist them in protecting their data and their sources, and to make recommendations for the protection both of journalists and the people that they collaborate with in and out of government. That all lies ahead. Tonight, what brings us together is this extraordinary panel that my colleague Emily will now direct and introduce. So I thank you for being here and for your attention. Emily, over to you.
President Bollinger, thank you, Dean Cole, and thank you all of you, including the late students, for turning out tonight for what we believe is actually going to be a very important year of work for us. And I was pleased to see my colleagues at the Tower Centre looking very enthusiastic as Dean Cole reeled off the very long list of things that we have to do. We're incredibly lucky to have this great panel with us here tonight, and I think this will be a great moment to address many of the issues that we've already had framed. But before I introduce them, I have two important pieces of housekeeping, one of which is to say that in true Columbia journalism style, I have to do full disclosure. I worked for The Guardian for many years. I now sit on the Scott Trust, which is the ownership body of it. So if you're worried that this is too cozy and close a panel, I'm here to tell you that you're correct in that slight anxiety. And it's your job to be the effective opposition. And the second is that we really couldn't have a better panel tonight, but we also know that there are many, many voices who are not included on the panel. There are the reporters who were involved in really finding the story, which is Glenn Greenwald, Laura Poitras, as Edward Snowden himself. We're very lucky to have Bart Gellman here tonight, who is one of the reporters who broke many of the stories through the Washington Post. When we've wrapped up the panel, I'll be going to Bart just to give a quick response to what he's heard, and then we'll be having some Q&A from the audience as well, so please be thinking of questions, because I'm sure there are plenty that I will not get to. So, to introduce the panel, on my immediate left is Janine Gibson, who is the editor-in-chief of Guardian US, which broke the initial stories. And next to her, we have Jill Abramson, who, as the editor of the New York Times on the Upper West Side, obviously needs no introduction. But nevertheless, we're absolutely delighted to have her here. She's a member of the Board of Visitors of the Journalism School. And also, I think it's fair to say that the New York Times is still the voice, the editorial voice, which is probably most listened to by the establishment in the US. I hope that's not too controversial. Next to Jill, we have David Schulz. David is a leading First Amendment lawyer. He's very kind to make time in his schedule to teach up here at the law school. He's a partner in Levine, Schulz, Koch, and Schulz. He is the Guardian's lawyer actually on the NSA, and before that he was external counsel to the New York Times on WikiLeaks, I believe. So he has been inside two of the biggest stories of this type. And then we're very, very pleased to have Cass Sunstein here. And I should have said that, one of the things we have sought is to get members of the administration or the NSA to come and talk to us. They're not quite ready for that yet. We hope they will at some point. Cass, as President Bollinger says, is one of the country's leading scholars in constitutional administrative law. He served in the Obama administration as the administrator of the White House Office of Information and Regulatory Affairs. He's an author. Many of my students were very, very excited that I'd be on a panel with Cass Sunstein tonight. And for purposes of disclosure, he's married to the US Ambassador to the UN, Samantha Power. But tonight, he's here as a member of President Obama's Review Committee on Intelligence and Communications Technologies, which was one of the panels convened in response to the revelations by Snowden. So we are going to address the what's for journalism after Snowden. But first of all, I want to go to Janine first, because I think some of us are very familiar with this, some of us less familiar. I want you to, Janine, can you just tell us about actually breaking the story? Tell us a little bit about how it came to you and then what it was like, so you can set the scene of what is it like to deliver a story of that size to the world?
Well, it starts very small, of course, like everything. It starts with a phone call from Glenn Greenwald. And I should say, The Guardian is a 200-year-old news organization with a storied history of breaking large stories. We did WikiLeaks. We are even accustomed to the mega leak. But in America, we're 2.5 years old, and we live in a small loft in Soho. And while we are all, we all have Guardian running through us, and our combined work history might be 80 years or so. In America, we don't look like a 200-year-old news organization. We call ourselves G by The Guardian, with the diffusion line in Soho. So I'm sitting in our Soho loft, and I get a phone call from Glenn Greenwald, who'd been working for us for, some months. And he said, I think I have the biggest intelligence leak in a generation, if not ever.
I like it when reporters undersell stories.
Well, obviously your first thought is, we might be the judge of that. But oddly, because of WikiLeaks and the various measures we'd had to take whilst working on WikiLeaks, I knew that Skype was not a particularly safe form of technology, and I knew that Glenn had a Skype phone. So my first question was, are you calling me from your delightful Rio residence on your Skype phone? He said yes, and I said, So we didn't talk very much in that conversation, and it became very clear that the first thing he was going to have to do was get on a plane. He explained that he was going to see a sample of the material, that he'd had encrypted conversations with the source. And of course, it's funny to remember now, we did not know his name. We didn't know his name. He was the source. And for quite a long time after we did know his name, we kept referring to him as the source because he had been the source for so long. So he was going to get this small sample of material and look at it. And he would call me back, and if he thought it was good, he would get on a plane to New York. Anyway, so within 5 days, he was in the Guardian Soho loft. And there were 5 of us in the room then. Myself and my deputy editor, Stuart Miller, and Glenn and Laura, and reporter Ewan McCaskill, who is, if in the entire universe of Guardian staff, if you could pick the person that you wanted to have sat outside your office when Glenn Greenwald walks in with the biggest intelligence leak possibly ever, it is Ewan McCaskill. He is, he's not here, so I can say grizzled. He's done everything. He's been to every war-torn hotspot. He was the DC bureau chief, talking war-torn hotspots, and he's the person you send to the fire, whatever the fire is. And when it became clear that we're sitting there on the cheapest sofa in the world on an air-gap computer that we've had to send somebody out to Best Buy to buy, looking at what it later turns out is the PRISM presentation, and you've seen those slides. They don't look like the most top-secret thing in the world. They look like somebody has gone a bit haywire with a PowerPoint. But, very quickly, you very quickly realize it's either, an incredibly a huge, sensitive, difficult story, or it's the Hitler diaries. You know, it's a great big hoax, and the next job is verification. So you move straight away into how do you verify it,
Right.
and how you verify it is put Ewan on a plane.
How long was the verification process?
It was really intense. We put Ewan and Glenn and Laura on a plane to Hong Kong, and they went to a hotel, and I think everybody knows a detail that was maddeningly reported first in the New York Times. They identified Edward Snowden by the use of a Rubik's Cube in a hotel lobby, and couldn't believe he was 29. You know, we assumed when we were looking at the material and the description of the rest of the material that this was going to be somebody very senior, this is going to be somebody, you know, really high in the ranks of NSA. We were expecting, and then we couldn't work out the psychology of it, because, you know, we're in New York waiting to hear from the people on the ground in Hong Kong, and you spend a lot of time speculating, what would cause somebody who's career NSA to walk out with the crown jewels, really? And they saw this, you know, kid walking through a lobby, and they just thought, that's not him. So then, of course, you're right into Hitler diaries. So, you know, we had briefed Ewan a lot on the sorts of standards of verification that we'd want. And they spent 3 days, you know, locked in a room, interviewing him, show me this ID, show me that car parking pass, talk to me about this. And they were very, very convinced by him. Mm-hmm. And his motives, and of course the material that he had, and then you move straight into, right, what is the story? What can we do? And the first one was clearly the Pfizer court order, the Verizon order.
It should be made clear that there are 56,000 documents. Is that right?
No, there are many more than that.
Right. Okay.
Many more than that. There are 56,000 in one cache alone,
Right.
Which was the cache that Edward Snowden gave to to Ewan.
Right.
But then, you know, there are several other caches.
Right. So does anyone actually know, can anyone quantify what the actual size of the leak is? I
don't think anybody knows. The NSA said for a while that they did know, and then they said they didn't.
Right. Okay, so just on the launch of the story, it's June the 5th?
Yes, so this is, again, we're working in huge amounts of secrecy at this point, and we have realised that communications with Hong Kong are necessarily going to be sparse and very highly encoded. We flew out, the first thing we did was fly James Ball out to New York. James Ball is a veteran of WikiLeaks and sitting in the second row and freakishly young, really annoyingly young, but brilliant at all things involving cryptology and technology. He can also fix a printer, but...
Very important.
Very important.
I didn't know that. We must hire him.
Yeah. Fix a printer without putting it on the network, yes. Crucially. But he came and introduced us to disposable chat rooms and properly secure technology. Then we had to teach Glenn and Ewan how to use it from London, but fortunately, again, they were being taught how to do it. I mean, quite seriously, if you're going to learn how to do encrypted technology, be taught by the person who works for the NSA doing encrypted technology. So they came back really knowing how to move documents around securely. But, you know, we're trying to edit, write, report, and stand up and verify a story about a document that nobody's ever seen. You can't Google secret Pfizer court orders to see if it looks like one that's in the public domain. There's nothing. No, that's not funny. That's a genuine problem when you're trying to work out what it is. But we realised, obviously, they have been referred to in reporting. And that one of the crucial factors around this document is that if you are the subject of a Pfizer court order, you are gagged. There's a gagging order, and you can't refer to it. So we knew the first call we had to make was actually to Verizon, and if the spokesman said, no, there is no such thing, then that was, he's not allowed to do that. But actually, I'm going to drop a minute, but they kind of called back. They said, well, what is it? Okay, we'll take some details, we'll call you back. And then they called back very quickly and said, sorry, can I just check, what's the name of the agency on the gag order, on the Pfizer court order? And what is the date? Which we were listening to this and thinking, it's a bit like, is it the pink one or the yellow one? And so we started to think, but up until that point, you've put a huge amount of work into it, enormous amount of money already, barely even started playing David's bills, and you're still thinking this could all be this could be nothing, this could be a massive, massive hoax. But when the Verizon call, so the Verizon call was tremendously important because we were working to a script at that point, but we also knew that that was a really big step in verifying the story. And then we spoke to the administration, and then it became very clear that it was, in fact, a genuine document. At which point, I always say this, but we're incredibly lucky at The Guardian. There's only ever two questions you need to ask yourself, and they are, is this story true, and is it in the public interest? And before we went down this road, we spent a lot of time with several lawyers making sure that our ethical, moral, journalistic interpretation of the public interest matched up with the legal interpretation of public interest, both here and globally. So then it really did come down to verification and is it true? And we have basically tried to hold on to those two twin pillars ever since. If you're really holding on to, is it in the public interest? And line by line, that's what we worry about. It sort of takes away from the enormous thing that you're doing by starting to publish these stories.
I want to bring Jill in at this point, because at what point did the New York Times get involved? Were you approached by The Guardian with the documents, or did you solicit them?
I would say it was a delicate combination of those two things. We, did not break the story The Guardian and the Washington Post did. That caused me, severe indigestion and a high degree of worry, needless to say.
What did it cause your newsroom?
Excuse me?
What did it cause the newsroom? Were you?
I think the newsroom was, resolute and, I think disappointed, as was I, that we didn't break the story. But, it was, not, I would say, at the forefront of the psyche of, my colleagues. But it was, a concern of mine. And, I felt that the Times had had a very productive collaboration with The Guardian on WikiLeaks. Obviously, the New York Times broke the Pentagon Papers story, which President Bollinger eloquently evoked in his opening remarks. And in 2005, we had published the first story about warrantless eavesdropping by the NSA. So I felt all of that provided a very firm base, that made a powerful argument that the Times had a constructive role to play in these stories. Actually, I heard from Alan the first weekend after the stories were published.
This is Alan Rusbridger, the editor-in-chief of The
Guardian. And we had a chat in my office the following week, and it was a somewhat vague conversation about collaborating, and maybe we could. And as any aggressive journalist would do, the door was a little bit open, and I tried to stick my foot in it and keep it opening a little wider. And from time to time, I would call Alan and just say, we'd love to work with you. And nothing happened for a while. And then he did get in touch with me. And the catalyst, I believe, for him reaching out to me was that he definitely had the sense that the British government was about to come down very hard on The Guardian and probably demand the return of the materials. And he was deathly worried that the public interest role that Janine spoke so powerfully about would be, the plug would be yanked. And
of course, that would prove to be the case.
Exactly. And, sometime before the authorities actually came to The Guardian and they had to literally destroy their drives and whatnot, the Times did obtain some, but not all, of the Snowden materials from The Guardian, and we agreed to abide by all of the protocols that The Guardian had established for keeping these materials as safe as possible. I think that's a really important point. It's not the sexiest point, but you were asking Janine about the process by which they verified the story. I would say the process by which the Guardian sort of schooled us in exactly how we needed to handle the documents, safekeep them, communicate in a very secure manner, that is probably, took up days of the two, Janine and me talking before we got a lick of actual work done. And I just think that point is somewhat lost on the public. Sometimes they think, oh, a leak, it's just a bunch of stuff that's thrown at us and we just rush to publish it. And that is never the case and could be the least true in this situation.
Mm-hmm. And I mean, this touches on something that I want to come back to just before I move on to Dave and Cass. The two of you, the size of these stories, the unknowable end, even with the Pentagon Papers, you could fit them into a shopping cart, and as in fact
Right.
they did, and wheel them across the newsroom.
Abe Rosenthal took them in an AMP cart to Punch Sulzberger's office. It's true.
And part of that was actually, sort of Ellsberg had to make selection choices, partly on the basis of what he could actually get out there. And now we have these unknowably large stories. They're technically incredibly difficult, but also isn't the opacity of them and the difficulty of them an enormous journalistic challenge? I mean, you've talked a little bit about the difficulty of that, but there must have been times when both of you thought, are we actually capable of reporting this story?
Well, I mean, I think from the beginning we realised we couldn't do it alone in different ways. I mean, again, just go back to, there was a very obvious point. We were running this as a new baby foreign edition of The Guardian. So the first thing we had to do was, call back to the parent company and pull in some help. But the second thing you realise is you're going to need outside experts. This is, we talk a lot about being open at The Guardian. It's one of our sort of philosophies of how we work. And this is a story which in many ways is the most secret thing you could ever do. But at the same time, you have to accept you can't do it alone. You're going to need security experts. You're going to need to consult with national security experts, technology experts, journalists who know more than you do about the subject, other news organisations because your material could get destroyed or because there's a chill in the UK. And we have brought in partners to work on an enormous number of the stories. And then on top of that, you sort of have to make up how you're going to assess the material. Mm-hmm. Jill's talked about, we almost had a contract about how we were going to search it. We were really keen that we weren't going to use these documents as a fishing exercise. There wasn't going to be a team with the WikiLeaks documents, which are much less sensitive, much lower level of classification. We would bring in, subject specialist journalists, and they could have a search, and we built special
And country specialists
to have a route round for stories. This is a very different sort of thing. You don't want to be using national security material to route round for all sorts of stories. You want to use it to confine yourself to the size, scope, legality, nature of the surveillance in front of you. So we have had all sorts of conversations about how to build boundaries about what we will report, and then all sorts of conversations about how best to do that practically. Do you put a small team in for 2 weeks, get them to winnow down a short list of stories, all the different ways you might do it?
That is what we did, and that is what we did in WikiLeaks too. And in both cases, we, the Times assigned, and working closely with The Guardian, a very small group of editors and reporters who worked together, not in the middle of the newsroom, but on a floor, remote from anybody else, and they exclusively went through the documents, and after that long process, then moved to the next phase, which is trying to put them in some kind of context, to start reporting. I mean, in our case, I thought some of what we brought to the table, were our reporters in Silicon Valley who had very good sources at all of the companies that the Guardian, its initial reporting, could see this was a source of controversy within the companies themselves. They had been required to cooperate with the government, but whether it was right to or not became a very live debate. And
Sure.
we could add reporting firepower on that type of thing, as well as inside the U.S. government and in the intelligence community.
That's a terrific, I think, almost kind of textual kind of background. You can almost feel what it was like to be in those rooms. I want to bring in David and then Cass now on the substantive legal issues that this brings up, and also the response, if you like, of legal minds and then the government to it. But David, to you first. You know, you've been on the inside of these stories. Is something changing? Obviously, the scale of the stories changed. What are the challenges legally, and where does the First Amendment fit into this?
Yeah, well, you know, it is a bit of a conundrum, because in this country, as was mentioned in the opening statements, we don't have an Official Secrets Act. We don't have clear laws about, and you can argue it's a very good thing that we don't. But on the one hand, the criminal liability, what we have primarily is an Espionage Act that was written during World War I. It wasn't
1917.
It wasn't intended to cover the kind of disclosures that we're talking about through the press to the public. It was to get spies. And for a long time, it was thought that that's all it dealt with. That started to change, and in the 1980s, for the first time, a source, not a reporter, but a source was prosecuted for leaking information to the press. It was a Navy employee who was working as kind of a freelancer for Jane's magazine in London, a defense magazine, with the knowledge of the Navy. And the condition was that he could write for them as long as he didn't disclose classified information. And then at some point, as he was negotiating a full-time job to go work at Jane's, he secretly provided to the editor some highly classified spy photos that were considered very sensitive at the time, because it disclosed to the Soviet Union the capabilities of our satellite cameras, or our high velocity, or the aerial cameras. And so it was he was prosecuted criminally. And there was a big debate at the time about whether the Espionage Act actually was intended to apply to this type of a disclosure, not to a foreign government, but to a news organization. And he attempted to defend the claim that the law just didn't apply to this type of disclosure. And his conviction was upheld, but in a kind of interesting opinion. He was raising essentially a public interest or First Amendment defense, in part. He said, I did this to a journalist, not to a foreign government. There's a public interest here. That was rejected, but it was tied to the facts of the case. It was, you know, the court said where there clearly was a bad intent, he was being paid for this. He knew what he was doing was wrong. He took off the classification emblems before he turned it over. He surreptitiously provided it to them secretly. The way they actually linked him up was through fingerprints, the old-fashioned way. So they said on the facts here, because of the bad intent and because of his knowledge of the harm that would cause, it was not a problem under the First Amendment to apply the Espionage Act to him. But two of the judges who decided that, 2 out of the 3, said, if you made the same arguments against the press, we think there would be real First Amendment questions here, and it would raise different concerns. So on the one hand, we have this very vague law, and on the other hand, we have this notion that the press is different, that there are First Amendment rights, a long line of cases that say that you can't prosecute the press, you can't punish them for publishing true, newsworthy information. That's kind of a settled principle in many areas, but it's not an absolute right. As we learned in a case called Bartnicki a few years ago, there's a balance that has to be done, even with true, newsworthy information. And we don't know how the court will deal with that when the balance is the public's right to know something versus a national security interest. It's never been decided. So we don't know quite what the risks are, but there is a real risk, because what the Espionage Act says is that it is a violation, a criminal violation of the law for a person who has unauthorized access, a reporter. If you get national defense information, it's not even classified information, it's an undefined national defense information. If you have possession of it, the mere possession, the failure to return it to the government, or the disclosure of that, can lead to a criminal violation if it is reasonably, objectively reasonable to believe that the disclosure could harm the United States. So it's a very broad law, and the government takes the position it doesn't require an intent to harm. It doesn't even require actual harm. If the document on its face could reasonably be understood to possibly provide harm, and in fact, a document shouldn't be classified unless it meets that standard. So you know that if you have a classified document, at least in theory, the mere possession of it is a violation of the law. So it becomes sort of a tricky situation to advise a reporter or a journalist how to handle that. But on the other hand, that's the bad news. The good news is, since 1917, there has never been, almost 100 years, there has never been a prosecution of a journalist. We have a very strong tradition in this country of protecting the press. And so there is this uncertainty, but that's the little dance we do. And so dealing with a situation like this, of course, there's a number of things you do. You want to limit the number of people who have access to this so you're not putting people at risk. And the basic advice is that if you're going to publish this information, it should be so important that the American people have a right to know, and that you could convince a judge, if you had to, that this was something the public needed to know. But it's still an unresolved question whether that even is a defense. The government has taken the position that there is no First Amendment defense to this law, and that there is no public interest defense, so it's a gray area.
And I want to just come back to that in a minute, but first of all to bring Cass in. Thanks, Cass, for being very patient there on the end. So in August, you're approached with the honour, or the dubious honour, if you like, of having to review this for the for one of the review panels. Can you talk a little bit about how you set out to do that, and what the four principles were that you looked at before we get into the findings and recommendations?
Okay, great. So we were constituted in late August, and it was a diverse group with one of the leading First Amendment scholars. He's associated with the American Civil Liberties Union, Jeff Stone. Has a prize-winning book on free speech, of which he's one of the nation's strongest advocates. We also had one of the leading, maybe the leading privacy expert in the United States, a guy named Peter Swire, who was the privacy person in the Clinton administration. We had a long-standing person in the CIA, Michael Morell, who had actually been acting director of the CIA with over 3 decades of experience there. He also, incidentally, is strongly committed to a free press and civil liberty. And Richard Clark, who is a counterterrorism specialist who has very strong convictions about freedom of speech and privacy as well. And then a regulatory guy with some constitutional background, yours truly. So the first thing we really decided to do was to try to learn as much as we could from people in the country. So we did something quite unusual, which is we asked for a public comment process in which we asked people basically all over the world. We made a global request for comments, and we got hundreds. And while some of them, as I recall, had to do with people wanting to sell us pencils and paper, which we already had pencils and paper, but most of them were substantive and about the issues at hand, and every word was read, and they were incredibly valuable. We also had meetings, extensive meetings with people all over, including people whose special interests, privacy and civil liberties, the rights of journalists, got a lot of information from that, and it really made an impact on our report. We ended up endorsing 4 principles, and I won't do them in exact order, because I think the first one I'm going to mention is maybe the one that's most salient today, which is there's a lot of talk about balancing national security against privacy. We think in important respects that's misleading and actually harmful. There are some things that just don't count in the balance. So if there's an effort to suppress dissent, to go after people because of their religious convictions, to target people because of their political beliefs, to go after people because of their gender or ethnicity, that's not part of a legitimate balance, that's just off limits. It's very important to identify a set of impermissible reasons for surveillance or anything like surveillance, and we say in the report that that is a foundational principle that applies inside and outside our territorial boundaries. So the first idea is the limits of the balancing metaphor as a way of approaching these issues. The second is by, I think, a happy coincidence of language. The word security actually has at least 2 meanings, 2 which are crucial here. And they both have a Latin root, which means free from danger, safe. And that entails both not being blown up or at risk of being blown up, and also feeling that your person's papers, effects, et cetera, are safe from government intrusion. And our view is that these 2 forms of security, which have the same linguistic root can both be safeguarded, and it's a big mistake to think that in a free society one can be pursued at the expense of another. One thing we're fighting for when we protect our national security is the other form of security, and it shouldn't be relegated to second-class citizenship. The third idea is that there are multiple risks involved that surveillance calls up. And it's a big error to think about only one. So national security risks are one, and they're very important to consider, and they're part of the mix. But risks to journalistic freedom are also one, and that has to be considered. Risks to our relations with foreign countries, including those who are friendly with us or are trying to cooperate, that's another. Economic and democratic risks that cut across territorial boundaries, that's another set of risks that might cut in a different direction from the national security risk in terms of what policies to adopt. And of course, risks to privacy, which are a central feature of the overall calculus. So the idea is we're dealing really with risk management, and the risks that are involved operate along a number of different dimensions. The fourth and final principle has to do with the need consistently to focus on the consequences of what government policies are, not only before the fact, but in an ongoing way. So if it's the case that you have some policies that were adopted, let's suppose, in the aftermath of 9/11, or a year or two before 9/11, to decide in a way that reflects the best practices of newspapers and businesses, which is to reinvestigate your practices to see what actually are they doing to people. So you may have practices that at one point were thought necessary to protect national security, but it turns out they're really not doing much on that, but they are scaring people or they are chilling the system of free expression. That has to be known and subject to continuing scrutiny, not just by the intelligence community, as important as it is to the scrutiny, but by a range of actors who include people who aren't maybe principally concerned with national security, but who have privacy and civil liberties as their mission, or who have internet freedom as their mission. And that last principle, that is balancing the human consequences, keeping your eye insistently on that ball, not only when you adopt the policies, but while you reassess them, has institutional implications. So we suggest important changes in the Foreign Intelligence Surveillance Court, and also important changes in the structure of the executive branch, where, just to give one example, we say there should be a designated official in the White House who has privacy and civil liberties as his charge. To have that person in the room, having a convening function and having a presence, can help ensure both that risk management operates along the full range of dimensions and can also ensure the kind of continuing scrutiny that a free society needs.
So can I just ask at that point, though, I mean, the recommendations, I think, probably went further than some people were expecting you to go, and certainly not as far as other people wanted you to go. So, for instance, on metadata storage, you said it should go to third-party or private kind of companies. It shouldn't be kept by the government. One of the other review panels had a slightly different view, which said shouldn't be kept full stop. I just wondered why you'd stopped short on that.
Okay, so to state our recommendation, we believe that the metadata, that is who the phone numbers are from and who's calling whom and when, the government shouldn't be holding that data. In a free society, if we're engaged in a risk management exercise, there are undue risks to privacy and civil liberty with the government holding that data. We think that the information should be held privately, which has a safeguard against the risks of abuse, which in American history have not been absent. Not in the recent past, I mean, not in the last years, but under President Nixon and President Johnson, there were risks from surveillance and before. Okay, so we don't urge that the information should suddenly be held by the phone companies. So that's not what we urge. The phone companies have that information. They hold it for consumer protection reasons, in large part. They hold it because they don't want to be billing you for stuff that you're not responsible for. In fact, the Federal Communications Commission, whose mission is not surveillance, requires that landlines, at least, that the phone records be kept for 18 months. They hold it either voluntarily or by FCC mandate. Like your bank has your bank accounts. We don't recommend, in fact, we recommend the opposite, that the government should be holding bank account records. We are big against storage of all people's metadata. In a free society, that's not what we're for. We're against that. But banks have the stuff. They just do. The government can get access to it through a warrant. That's the system a free society designs. We don't urge that the banks should disassemble people's bank accounts because it's dangerous for them to have it. We urge that the government should not get access to that information except in accordance with the standard legal forms. What we urge here is precisely parallel to what's always been the case in a Fourth Amendment respecting situation. Materials held in private hands, and the government has access to it on the basis of the appropriate showing.
There are many more recommendations, but I just wanted to bring back the whole panel. We're here to talk about, journalism after Snowden. And actually, the very important legal point, and Dave, you touched on it, which is, we had the Director of National Intelligence, James Clapper, yesterday saying, well, first of all, two things he said. People with material should give it back. So, Jill and Janine, do you have a response?
Well, now you say that.
But the other thing that he said was he talked about Edward Snowden and his accomplices. And after a couple of calls, the clarification from his office was accomplices could potentially mean journalists. Now, given what Dave was saying about the Espionage Act, do we even know what the policy is for the Obama administration? Because the Attorney General in the summer said that in the James Rosen case, who is the Fox reporter who was had his phone calls, I think.
Email.
Yeah, his email taken. He was actually described as a co-conspirator in leaks. The Attorney General sort of stepped back from that. But there's a great deal of, there's a lack of clarity, isn't there, here, about whether we even have a policy around this. I don't know whether Cass or Dave, you can respond to that.
Well, I can tell you a lot about the Obama administration's policy with respect to the Paperwork Reduction Act, which I was helping to oversee, and I can tell you a good deal about our policies with respect to cost-benefit analysis and environmental stuff. The other I wasn't involved in, so I don't have a view. I don't have a view of the policies.
So David, what do you think?
Let me just maybe tie a couple of points and throw some issues out. But yeah, I think that one of the points you're raising is that we have to have, in the way our system works, if you have a system of free expression, there has to be a basis for confidential communications between reporters and sources. That's one of the things that the Privacy and Civil Liberties Oversight Board underscored in their report that came out, I guess, last week or the beginning of this week. And I think the concern, which is evidenced by all the interest in this, is that the Snowden revelations kind of were a wake-up call. Jill is right. We knew a lot of this was going on in 2005, and people have reported on it. But seeing that FISA order that said, give us everything.
It was the scale of this that's different.
And what we're realizing now is that, it's not just the phone records and all the good things we could say about the recommendations on metadata, which they are very helpful and very strong in good ways. It's a piecemeal approach. Because we also know they're getting not just your phone records, but they're getting email in various situations. They're getting geolocation data. They're getting your contact lists and your buddy lists and all sorts of other information that they get in various ways, from your cell phone, from various websites. So part of the problem is, it seems to me, what we need as a society is we really need to understand what we mean by privacy. So we talk about protecting privacy. 2 years ago, the president and the White House got behind an initiative that was geared at private industry. It said we need a consumer's privacy bill of rights because all these corporations are collecting your data. Well, we need a privacy bill of rights. We need to know what it is that the government can and cannot do, what corporations can and cannot do, and we don't have a consensus on that. And Europe has a whole different view of privacy than we have here. And in many ways, it's more refined and more forward-looking when it comes to data protection. And it's going to affect things like reporting. What the Attorney General said this summer in reaction, and just if you weren't following it, I mean, what happened is the Department of Justice wanted to get the email of a Fox reporter because they were doing a leak investigation. And because of an anomaly in the law that says you can't get, there's two laws that were relevant. One says that you can't get email unless you get a search warrant. They wanted to judge so that you can't just do it with a subpoena without having a judge approve it. So that is one law. There's another law that says you can't use a search warrant against a reporter because you want to give the reporter notice with a subpoena. In any event, so they were in this crosshairs. They wanted the email, so they had to get a search warrant, but they couldn't get a search warrant against the reporter. The exception to that is if the reporter is suspected of a crime. So they actually filled out an affidavit and got a search warrant where they said that there was reason to believe that this Fox reporter had violated the Espionage Act, or at least was a co-conspirator, because he was asking questions of someone who had access to classified information. And there was such a reaction to that, the Attorney General said at the time, we will not prosecute journalists for doing journalism. But what does that mean, is where we are.
I can say something that I think is an issue for journalists and citizens for the next 20 years, which is there's been a distinction in law and more generally between metadata and content. So some people have a thought that if government has access to your phone calls, that's really troubling. If they have access to metadata, meaning what numbers are calling what numbers, that's a completely different problem. We in the review group are uneasy with that distinction, that if the government has access to knowledge about whom you are calling and when and where, meaning the numbers, and it can figure out who those people are, that's a privacy problem. And that needs to be, that distinction between metadata and data needs to be rethought. Very possibly for constitutional purposes, but even if the constitutional heavy artillery doesn't come, certainly for policy purposes. The idea that government has, your metadata, it can tell a ton about you. And whether it's going to be used illicitly or to target people on the basis of illegitimate grounds, probably that's a risk and not a high one under current circumstances. I'd even say a very low one. But in terms of the kinds of security which people in a free society are entitled to, and certainly journalists and their sources, that's something that needs to be reassessed.
I just wanted to now to, as it was, sort of, bring that conversation right back to, the fact that the title of this is Journalism After Snowden. I think we can all agree that Edward Snowden has done us a favour. Do we have general agreement on that? That Edward Snowden has done us a favour. Can we agree on that?
Who are you asking?
I'm asking the panel. Can we all agree?
I have no comment on that. We have a 300-page report, and the word Snowden doesn't appear in the report. And
but just to pick up on that, I think that's isn't this sort of goes to the heart of the issue in a way, because you've recommended lots of, I think, recommendations that people would generally endorse, and the critics, as I say, of the administration would endorse them as well. But the fact is that we've had oversight, and oversight has failed. And where oversight has failed, a whistleblower and journalism has succeeded. And yet the system is still wanting to punish, if you like, the the one thing which has led to some sort of transparency and clarity.
But that should be completely unsurprising. I think useful backdrop to segueing into how journalism is changed after Snowden is to acknowledge that during the Obama administration, there have been 7 criminal leak investigations, more than twice all of these investigations in all of history before President Obama took office, and that this has had a profound effect on journalists who cover national security, with the Snowden case being only the most
And I think,
recent.
to your
That
question-
this seems to be, if not a stated policy, a reality where journalism about sensitive national security issues that I see as vitally in the public interest is effectively being criminalized, and a real freeze is setting in what had been to this point, I think, a healthy discourse between sources and journalists. And I might here cite, if I can take just a minute,
Sure.
because the gentleman had quite a long bit of time to speak, is to point out that Max Frankel, in a very famous affidavit in the Pentagon Papers case, wrote eloquently about how the public does benefit from this discourse. And I have seen both in the job as Washington bureau chief of the Times, certainly then growing as managing editor and now as executive editor, that these criminal leak investigations have had a very profound effect on journalism.
Sorry, can I
Yes,
just
go on.
come back to the accomplices point? The thing that was completely different about this story, as journalists, we all understand that at some point somebody might threaten you in the means of trying to get you to reveal a source, and there's a sort of tenet that you learn in places like Colombia that you would go to prison to protect your source. This source never thought his identity wouldn't come out. The very nature of the story, he knew exactly how fast they would be able to track him down and identify him as soon as the revelations appeared. And the reason that first fortnight was so intensive for us was the idea of getting as many stories out as possible before it just became about source hunt, witch hunt, who is this guy? And for a 29-year-old, he had an eerie prescience, because he knew everything that had gone before, about what would happen, what they would say about him, what they would try to, how they would try to characterize him, and he wanted to be sure to be able to control his own story. But what that means for the journalists is, instead of the position that your journalists find themselves in, where they're being threatened with prosecution over identifying their source, we are now being put in this position of something even more chilling, of being co-conspirators. The sort of basic fact of who is your source, well, I'm not going to tell you, has become you're part of a conspiracy, possibly involving the KGB or maybe China, because the original, the ordinary way of chilling journalism won't work in this case. And I think that should be profoundly worrying, because that's not going to stop. That is a journalism after Snowden problem. We're not anymore going to be worrying about naming names. It's going to be about proving that you're not a co-conspirator.
And to play devil's advocate, to say that this chilling effect, or first of all, on a panel of editors and lawyers, isn't it now just not possible to promise source protection or client confidentiality? How can you possibly guarantee that, knowing what we know now?
It's really problematic. There have been stories that we've had since Snowden, where a journalist who has had a source who they have been dealing with for a number of years on relatively innocuous bits of colour and detail around a story, suddenly wanted to give them something much more serious and profound. And you're looking at them and going, right, so there will be a Gmail trail going back some years of your contact with this person.
But this is kind of
I mean,
inevitable.
it's amazing to me, but over the course of the past decade, journalists literally saying to a source, I will go to jail to protect your identity, those words are now uttered.
Well, you have a reporter in James Risen who is currently fighting that fight.
Quite worried about that possibility, indeed so.
So I want to leave plenty of time for questions. We have roving mics here. But I just wanted to kind of like wrap up on, so this point about there's an inevitable arms race here of technology, and Cass talked about balance, and which allows us to do all sorts of things, but it also leaves our fingerprints all over the world. And these are things that can be useful for governments and for journalists and for all sorts of people. Is this a legal remedy that we're thinking about here? Is it a technical remedy? Kind of where do we even start with this, given that technology and law are so incompatible?
Okay, so there's so many great topics here, and they're diverse. One topic is getting democratic governments on a sound foundation with respect to these issues, bracketing the leak question, which is a different question. And you could think that the idea of government storage of private stuff, metadata or content, that's just not acceptable in a free society. And we think essentially that's a good thought. You could also think that the government's access to such material, when the government wants it, should be qualified by what free societies insist on, which is an independent, neutral arbiter, a judge, agreeing on the basis of a certain showing of need. And that has served this nation at least quite well when it's been observed. And that's also a good foundation. So in a way, this is about taking forward some not new ideals in a radically different technological environment and insisting on their enduring value. And so that's good. That's one set of issues. Then there's another set of issues which are raised about private ownership, and that raises different challenges. And the Consumer Bill of Rights thing is about that.
I'm going to go to Bart Gelman, who is here in the front row. So, Bart, you've been listening to this. I'm glad we've got a year to do this now, because there are so many things that we haven't quite got to, which I think needs really deep discussion. But I wanted to call on you as a reporter and somebody at the heart of the story as to what you think.
Sure. Thank you for including me. I'll try to do deep discussion in a couple of short minutes. I wanted to parse what the Director of National Intelligence said yesterday about accomplices and about returning the documents, and put that alongside something that happened down the block at the Judiciary Committee, where the Attorney General said that he had hoped to release publicly the actual new guidelines they were using in investigations relating to reporters and sources, but that a glitch had arisen and he was not yet ready to release these guidelines. So what could James Clapper mean when he says that Edward Snowden and his accomplices should return stolen documents? I mean, the only other people who are known to have these documents are a small number of journalists. It could be just a rhetorical expression of anger, perfectly understandable for a secret agency that's had its secrets spilled for a long time. It could be an actual request for assistance or help, but if that were the case, you would expect that the government would have come to the news organizations quietly before or even after, and it has not done so. Or it could be a kind of signaling, a kind of a way of saying that there's a risk here. Accomplice, sort of has meaning in criminal law, as does co-conspirator, as does aiding and abetting. But there's, besides the actual risk of prosecution, which I think still is remote for the reasons that Dave has described, there's an investigative issue that very much relates to the ability to do national security journalism now. Almost everything you want to write about, if you're writing about diplomacy or intelligence or defense, is classified. Everything but the press release and the news conference is classified. That's just the way the US government works. There may be more classified information now than there is open source information on the planet. There's a good article that a Harvard professor wrote estimating that that's the case. And if you have an intelligence service that is capable of aspiring to, quote unquote, collect it all, that's living in the golden age of signals intelligence as it describes internally, in which the president says that bulk surveillance, that is to say, collecting as much as possible, isn't, to say, bulk collection is not surveillance. Bulk collection is not spying. That it's not spying until they actually look at it and make use of it. So it's all there in the tank, not only the phone records, but lots of things that the review group did not have within its scope to consider. Then think about the situation for reporters under these national security frameworks. You have all the information in these big buckets. The law has been interpreted to mean that talking to a reporter, giving information to a reporter is espionage. Counterintelligence, counterespionage, is a valid foreign intelligence purpose as far as the NSA is concerned when it searches its records. So now the leak investigation is potentially going to be over before it starts. They have all the records of almost every reporter's communications with almost every source. You have to take extraordinary precautions to limit that are very hard to take and hardly anyone tries to take. They are allowed, they can meet a reasonable articulable suspicion standard or even a stronger standard when it comes to whether the records of a reporter are going to be relevant to a counterintelligence investigation if the investigation is who talked to a reporter and disclosed these classified facts without which there would be no story. So this combination of sort of operational, technical, legal tangles is what we have to address if we're going to seriously talk about sort of national security investigative journalism in the post-Snowden era.
Thanks very much indeed, Mark.
Could I just pick up on
sure.
that?
Can people put their hands up for questions, and we'll go there and there, but just while we're getting the mics to you.
I just want to underscore the point in a slightly different term. I mean, what Bart is saying, and the issue you're raising about the reporter's privilege is the technology that we have today. When you acknowledge what the government has and what it can do, you don't need to subpoena a reporter anymore. There is an ability to find out who gave out any information. And we should all be very concerned about that because we need whistleblowers. I mean, you could look at the number of stories just in recent years, you know, secret CIA prisons, waterboarding, abuse of patients at Walter Reed Hospital. You can go on and on and on. Important stories that only come from classified information. And if we don't have a mechanism that allows whistleblowers, our whole society is going to suffer. We can't count on oversight by Congress and the courts to adequately perform certain types of tasks. And if we don't acknowledge that and have some safeguard, and one of the things that, you know, hopefully will get picked up in the review group proposals are that things like the national security letters and FISA court orders should be subject to the same Attorney General guidelines, that you don't go after reporters with those at a minimum. And right now there's just a gray area there. None of these national security things do you need to go through the normal checklist of before you go after a reporter.
Right, I'm going to take questions. Can I go, somebody's on a microphone, I think, over down here and then over there. So can we start here? Oh, sorry.
It's over here.
Okay. Yeah. And then at the back. In fact, if anyone's got a microphone, can you ask a question? Sorry, sir. It's such a big hall, it should be in a smaller venue.
Yeah. Hi, my name is Daniel. I'm from Germany and a journalism student here at Columbia. I just wanted to ask, because the sources for the documents in the WikiLeaks case and in the Snowden case were both activists/journalists, and the documents are not in whole at the Guardian's office. They are like controlled by Glenn Greenwald, as long as I'm informed. So, or was that what I heard? What does it mean for this whole insecurity about investigations into leaks and sources? Like, how much do you have control over the situation as the editor-in-chief of the Guardian or of the New York Times?
That's a great question.
It's a great question because, I mean, this is one of the things that we were having conversations about in the UK for quite a lot of last year. We were holding some of the documents in the Guardian's UK office, and then various other documents are held in other places, which I'm not going to go into on this platform. But including very securely in the New York Times office. One of the problems with the UK government approach, and it is bitterly ironic to me when we're having this conversation about the US context, that I spent quite a lot of the back end of last year in the UK saying we could not report this story without America. We wouldn't have got this story if we weren't the Guardian's US edition, and we wouldn't have been able to continue reporting it if we weren't the Guardian's US edition, and if we wouldn't have been reporting it for the last 8 months without the Guardian being the Guardian in the US, and then to suddenly realize that it feels slightly like driven out. But to address your point, once the UK government tried to remove The Guardian from the equation, we spent some time saying to them, do you not remember what happened with WikiLeaks? Once you remove the news organization with the 200-year tradition, history, values, legal resources, concern about public interest, the incredibly fine-grained judgments and brilliant reporting that go on in these organizations, if you remove them, the information will find its way out in a way that you cannot engage with, that you cannot discuss. We have talked to administrations and agencies in 2 continents, at least, on every single story we've done. We've engaged with them, we have asked them questions, we have talked to them about the material we intend to publish, and listened to their concerns. We don't always do everything they say, of course, but we now do it earnestly together and in partnership. The idea that by restraining us because we can be the subject of a legal order, they will somehow contain the problem, you only make it worse. At one point, we were saying to the UK government, we're your best friends in this endeavour, really. You're going to shut us out of it, but that's what they did.
Right, now take a question back, and then down here. Yeah.
Yep. Hi, Louisa Rogue. I have 2 questions, and I guess they're mostly for Jill and Janine. The first one to Janine is maybe you could talk a little bit about how the discussion in Britain has been versus the discussion here in the US, because it seems that it's been a very different discussion in the UK, and the sort of the kind of collaboration that you've had here with other media organizations on this story, that certainly that kind of collaboration hasn't taken place in the UK.
No, it's impossible to describe the wall of silence and refusal to engage that was the rest of the British media. I mean, the US media from the very beginning has been brilliant in this story, that everybody, obviously the New York Times...
Some of them thought you were traitors, though.
And very few of the US media thought we were traitors. I mean, momentarily on Fox News, but they've come around. I'm talking more about the reporting endeavour, the AP, Reuters, Wall Street Journal, of course, Washington Post, New York Times, ProPublica. I can't think of a major news organisation in this country that hasn't used the release of these documents to break a story, to do some amazing investigative reporting on this topic, and really pushed ahead. No other news organisation in the UK has even followed up stories.
Not even the BBC.
No, I mean, it's been extraordinary. And then I suppose, regulatory environment, or that seems a strange word to use. You know, they have been refusing to rule out prosecuting Guardian journalists for some months now. Obviously, we know about the detention of David Miranda, partner of Glenn Greenwald at Heathrow Airport. The Guardian has been funding a legal action to try and rule that outside the bounds of the piece of legislation that he was stopped under. But frankly, UK law is so widely drawn, it's almost impossible to overstep the oversight regime there. The defence of the UK security industries, who are the NSA's hand-in-hand partner in a lot of this venture, is, well, you haven't proved any wrongdoing. It would be impossible to prove wrongdoing against the UK laws. There's very little oversight and guidelines. And Guardian staff are, as far as we know, still being investigated.
Yes. Yeah.
Conrad Martin with the Fund for Constitutional Government. And I want to go to the term that you used, which was Edward Snowden's eerie prescience, and instead say it was more of an informed and healthy paranoia.
That's fair.
Because what had gone before him, if you looked at the Thomas Drake case, where they went after him under the Espionage Act, and he had taken the documents to House Intelligence Committee. Those documents were turned over. Diane Rourke got the documents, and this has been well written by Jane Mayer. The FBI raided the House Intelligence Committee staff director's office in going after that data. So the healthy paranoia that's there, and my question goes to, and you mentioned the whistleblowers, is where are the reforms that we've known that this has gone wrong? The Espionage Act does not work, hasn't worked, it's been overly broad. And the Enhanced Whistleblower Protection Act that should have been extended to contractors on national security issues was not extended to contractors. So the recommendations that are coming forward about the metadata. They're coming forward about third-party people handling them. But the underlying systems of how we're going to approach this in the future, and it will happen again, is not being addressed. And finally, when these things have come out before, like COINTELPRO, what happened was you had a Frank Church that came forward with a new regulatory structure on how these things are going to be handled, and that the Congress has been completely silent.
Well, not completely silent, but you know, you saw Senator Wyden just in the interchange with Mr. Clapper this week being pretty vocal, and you know, I think that's you know, I agree with much of what you've just said, but you know, what is tremendously unhelpful, I think, is to have statements, as in the hearing the other day, saying that Snowden's disclosures have done grave harm to the national security without any kind of specific information that helps the public, let alone journalists, evaluate the truth of that statement. Is just, to me, troubling. And, you know, it reminds me, you know, history is often a guide in these situations, that during the Pentagon Papers case, the Solicitor General, Erwin Griswold, made the passionate argument that disclosure of the Pentagon Papers was very harmful to the national security. And a mere few years later, after he had left office, he was asked, what harm to the national security did the publication of the Pentagon Papers cause? And he admitted none. In this case, none of us know, you know, how to evaluate the truth of what Mr. Clapper said the other day. But the lack of specific information, I think, is harmful to the public's ability to figure out where the truth in this situation lies.
We've got a question at the back. I know we're a little over time. I'm going to wrap up soon, but we've started a little late, so.
Years ago, Nathaniel Blumberg and to some extent Carl Bernstein pointed out the ways in which the media collaborate with the government and cooperate in the suppression of stories. If the government, this is for the two editors, if the government asks you to suppress a story because of national security, do you ask them for proof? What does it take to make you toe the line, which happens so often, for example, in the lead up to the Iraq War, in the coverage of the environmental disaster of 9/11 in the early days following the disaster, in the way that Robert Kennedy Jr. said that his family did not necessarily endorse the Warren Commission? That was not covered. How did that happen? And I'm from collapsenet.com.
No, I think what Janine was saying a few minutes ago about her efforts to make the case to the British government, we're your best friends. We are a responsible filter for evaluating the importance of the information, what should be disclosed, perhaps even what shouldn't be disclosed. And I think that the New York Times and other news organizations play a very important role in trying. It's difficult. As an editor, there is no set principles or a formula that I can follow in terms of when the government says to us, if you publish this, it's going to harm the national security. But when the government does make that case,
which it did with the original NSA
yes, of
wiretapping
course.
story.
I mean, we take those requests very seriously. We, in general, hit the brakes a bit in order to really give thoughtful consideration, to give the government ample opportunity to persuade us that such is the case.
To play slightly devil's advocate, though, the very fact that everybody was so shocked at what Edward Snowden revealed, wasn't that to some extent a kind of a mass failure of the press? Just in the same way that, you know, holding the government to account over Iraq was a failure of the press, that the fact that, you know, a whistleblower has to come forward with so much stuff, which, you know, has been available to so many people, you know, has American media really been asleep on
I don't think it has been asleep any more than, you know, again, I keep invoking the Pentagon Papers, but basically until Ellsberg, who was a principal whistleblower of the same ilk as some of the more recent cases, basically took him to expose that the Johnson administration had given a complete false history of the Vietnam War.
I think your question is about the duty on the press really to respond to a whistleblower. If somebody is brave enough to leak information and bring information to a news organization, then our absolute duty is to publish it and to do the very best job we can to get as much of it out. And I think very much that was what Edward Snowden had in mind. That was his absolute primary consideration, was he wanted it dealt with responsibly and carefully. He did not want it spilled all over the internet, but he wanted it published, and we take that very seriously.
Can I add a quick point? Okay, I'm going to step a little outside of the review group here and just try to complicate things a bit. John Stuart Mill, in a great essay on Jeremy Bentham, said Bentham was like a one-eyed man who was blind in one eye and could see further, but he didn't have the perspective. And some elements of the intelligence community at some points in our history has been like that. It's blind in one eye and they can see really great on one dimension, but they don't have perspective. I do think there's a risk that in thinking about leakers, that we're blinding ourselves in one eye. So I guess I should just say that there's no one on the review group who would describe Edward Snowden as a whistleblower, not the civil liberties focused Jeff Stone, and not the privacy protective Peter Swire. We didn't discuss him, but that's just a fact. And whatever you think of that particular person or any particular person, the topic is after Snowden. And to leak classified material, that's very complicated from the government standpoint, how to handle that. Prosecution is a very severe act, but you can think of it in two different ways. One is if it's just formally classified, that's presumptively grave. That might not be the right view, and it might be, as I think Jill's suggesting, that the classification isn't sufficient. It would have to be also a grave thing to do. We call in our report for declassification, especially of the FISA court opinions, but we call for a lot more transparency, and we're committed to that. But in thinking about particular issues, I think it's really quite important not to be like Bentham. It's complicated on both sides.
As I say, just very, very quickly, 2 questions, and then we will really have to finish. So.
Hi, Parker Mitchell. Thanks for a great panel. The question that I have, it seems clear that we're going to have a big privacy debate over the next months and years. And the counterpoint to the government looking at all of our data is the public opinion, well, I'm not doing anything wrong, so what does it matter if the government's gathering data if they're going to do something good with it? And so the question I have is, do you think that this debate is going to play out in legal ways or within the elite public policy circle, or does public opinion matter? And to the journalists on the panel, has journalism done a good job explaining to the public what are some of the implications of privacy and metadata and things like this being collected for members of the general public over the next months and years as the debate plays out?
Thank you. That's a great question. Essentially, has the dial moved on what's going to happen?
Well, I hope so. I do think that, the fact that we're having a national debate about these issues, and I do think it's very important for that debate to call out in particular the rights and contributions of journalists, as our report does. That's indispensable to a free society. And The fact that there are surprising coalitions is actually, in a way, encouraging. We don't have the simple splits between Republicans and Democrats, and that does give an opportunity, maybe a window, for reforms that will have more stable foundations.
Usually journalists are very
I would,
pessimistic.
I would just say it's a great question, and I'm humble enough to believe that probably journalism could indeed, very complicated issues, do a better job of explaining all of this to the public.
And I would say 8 months in, we are still trying to explain in better and better ways to the public what this means, what the potential abuses are, what the actual abuses are. But the opinion polls show that the public is moving has gone from a position of, oh, well, it probably who cares, into a, actually, no, I really do care.
Yeah. I just want to say, I question your assumption that the public doesn't really care. I think the latest poll said something like 71% of people said they're concerned about the collection and sale of data just by private corporations, let alone what the government's doing. The percentage of people on Firefox who are saying, don't track me, which is, to try to keep some, has gone up, it's more than doubled in the last 6 months. So I think people are concerned. I think one of the problems is that people don't understand fully the implications of it. Like I was talking about earlier about the need for confidential communications in a lot of ways. That may not affect you, but it'll affect the information you learn, what you know about your government, if we don't have protection of confidential communications. And I think one of the things that the question raised earlier about the church commission and all the, one of the things that's a little unfortunate right now is that we haven't had anyone willing to take up the cudgels and say, well, before we can decide where to go, we really need to let the people know what's going on. We only know little bits and pieces, and that's never going to come out unless someone in authority says, we need a commission like that. We need to come clean, at least to the extent we can, in ways that aren't going to damage our security, in a very comprehensive way so we can assess this. And no one's really calling for that right now. The review group didn't call for that.
I am going to have to call time, but I just want to ask one single question, which is, if there's one thing that happens after Snowden for journalism, and you could wave a magic wand and make it happen, what would it be? Cass, you've had the advantage of studying this, so I'll let you go first.
An international norm or agreement that safeguards internet freedom, number one.
David.
I would follow that thought, but say an international norm, a convention of some sort, that defines privacy rights and empowers people to control what they want to control.
Jill.
More great stories to cover.
I'm so glad. I was really worried that they were all going to say world peace, and I was going to go, I don't want any journalists to be prosecuted, which is really, but that I really, an international agreement that journalists will not be prosecuted for doing their jobs.
And clemency for Snowden?
Oh, yeah. And world peace.
I'm sorry it ran long. I failed in my job as chair, but it was such a great discussion. Can I thank all of the panelists heartily, and thank you, the audience.
That was interesting. God, this could go on for hours and hours and hours.